Good morning, everybody. After some panic technical difficulty, I am connected to our meeting on my cell phone. Internet went down in my office about 10 minutes ago, which is really handy. But we have technology, so we'll adapt. So before I introduce our speakers, I'd like to go over some basic housekeeping issues. First, please hold your questions until the end. We'll have a Q&A period where all of our speakers will be available to answer as many questions as possible. Sometimes we don't get to all the questions just because of time constraints, but we will do our best to answer everything that comes up. Once the Q&A period is open, you can type your questions in the Q&A section that you can find at the bottom panel of your screen. Most of you are probably quite familiar with Zoom by now, but just in case you're not, there's a Q&A button at the bottom of your screen. If you're not already a member, I encourage you to join the Real Estate Board's Facebook group. You can also keep an eye out for the board's regular emails or visit rebgv.ca for information. Now let's meet our first speaker. We're actually very lucky to have two representatives from the residential tenancy branch with us this morning. Erica Popovich, I know I didn't butcher her name because I asked her, Acting Senior Information Officer, and Josh Gomez, a Policy Analyst with the residential tenancy branch. Erica will be presenting and Josh will be assisting during the Q&A portion on policy-related questions. Erica has been with the residential tenancy branch, RTB, for 3 years as an information officer, as senior information officer, and an acting supervisor. Throughout her time with RTB, she's developed into a subject matter expert in BC's tenancy legislation and internal RTB processes, allowing her to make presentations to citizens, stakeholders, and support groups, as well as design and deliver staff training programs internally. Erica is passionate about education and hopes to continue to gain and share her knowledge with citizens and colleagues. Josh has been with the residential tenancy branch for the past 4 years as policy analyst. Prior to that, he spent some time with the branch as an information officer as well. Throughout his career with the RTB, he's recognized the importance of educating both landlords and tenants in promoting positive, and my screen just flipped off. I'm having so many tech issues this morning. Positive interactions with the public and members. So I'm going to hand it over to Erica for her presentation. Erica?
Thank you so much, Darcy. Good morning, everybody. Thank you so much for having me. So I will just pull up my presentation here and then we can get started. So just as a preface, we are going to be going, I would say we're not going to rush it, but we're certainly going to go a little bit quick to maximize the amount of time we have for questions at the end. So let's just get this started. There we go. Okay, so can everybody see, or can some humans see my presentation?
Yes. We're good, Erica.
Awesome. Okay, thank you so much. So again, hello, my name is Erica. Thank you so much for having me today. My colleague Josh is also on the line and he will help with questions at the end of the second presentation. So our plan here today is to review the main changes and leave time at the end for questions related to changes that were implemented due to COVID-19. So let's hop into it. Okay, so hot topic, masks. As outlined in the mask mandate order issued on November 24th, masks are required for everyone in most public indoor settings. It's important to note that a face shield is not considered a substitute for a mask because it has an opening below the mouth. Now, there are exceptions for people who have health conditions such as physical or cognitive or mental impairments who can't wear a mask, as well as for those people who can't actually remove the mask on their own. Children under the age of 12 are also exempt from this order. So although there is no current order on masks in shared living spaces, Emergency Management BC anticipates issuing further orders on masks to include common areas of apartment buildings, condos, and workplaces. For now, it is strongly recommended that masks be worn in the following areas. So common areas and shared facilities in apartment buildings and condos, including elevators, hallways, lobbies, stairwells, laundry rooms, and exercise areas. Okay, so accessing rental units. At the start of the pandemic, landlords were unable to access rental units, but those restrictions have since been lifted. A landlord can now enter a unit to make repairs, to do inspections and show rental units to prospective purchasers or tenants, but it's important to follow the guidelines of the public health officer. So landlords must give the appropriate notice to tenants, meaning they must give written notice, and it must be received by the tenant at least 24 hours before the time they want to enter. Landlords should wear a mask. Proper notice also applies to realtors selling tenanted units. Notice must be given every time a landlord or realtor wants to enter the unit unless a predetermined showing schedule has been agreed upon by both the landlord and the tenant. Rental and home viewings are restricted to a maximum of 6 people if space allows. Those hosting viewings must use layers of protection like masks and support virtual viewing options such as much as possible. So that could be videos or virtual tours. Physical distancing and proper cleaning protocols should be followed and should continue to be followed. With regard to open houses, the Real Estate Council of BC is advising realtors to not hold open houses at this time. When communicating with prospective tenants or buyers, landlords and realtors should consider showing vacant suites rather than occupied suites if possible, using virtual tours, video conferencing, photos, and online floor plans, sending documents via email and using electronic signatures, using online payment methods, conducting communications by email, phone, or video conferencing. Okay, so regarding common or shared areas, a landlord can reasonably restrict or schedule the use of these areas to support physical distancing and prevent the spread of the virus. This applies to both tenants and their guests. A landlord cannot prevent or interfere with access to the tenant's rental unit. Some temporary restrictions to common areas would be considered reasonable if they are made to protect the health, safety, and welfare of the landlord, tenant, occupants, or guests. If the restrictions were set up to comply with an order of a government authority, that would be considered reasonable. So some reasonable restrictions could include things like closing access to gyms, rec rooms, pools, and hot tubs, places where physical distancing cannot be maintained at all times. It's also reasonable to limit the use of elevators to 2 to 3 passengers at a time, or limiting the number of residents in laundry facilities at a time. Landlords could also consider creating a laundry schedule for managing the number of residents in the room. Landlords should make every effort to allow tenants to have safe access to laundry rooms. It is unreasonable to require tenants to quarantine for 14 days after a trip locally, such as to the store or a doctor's office. It is also important to note that if a service or facility is restricted in response to an order of a public health office during the COVID-19 pandemic, tenants will not receive a rent reduction. Okay, so another hot topic, rent repayment plans. So in August, the government introduced a repayment plan to give tenants a reasonable time frame to pay back any rent that they owe from the time of lockdown, when evictions were halted. So the dates for that period are March 18th, 2020 to August 17th, 2020. Under that framework, landlords must give their tenants a repayment plan for any unpaid rent or utilities that were acquired during that period. If the landlord and tenant already had an agreement before this direction came out, it can be replaced with a new agreement by either the landlord or the tenant. This framework in place means a landlord can't end a tenancy for unpaid rent or utilities that came due during that period without giving a repayment plan for the unpaid rent or the unpaid amount. As long as the tenant makes the payments laid out in the plan in full and on time, they can't be evicted for those amounts of unpaid rent or utilities. However, if the tenant defaults on the repayment plan, the landlord can give the tenant a notice to end tenancy. Okay, so for repayment plans to be valid, they must include the following 4 basic terms. So the repayment period starts on the date the repayment plan is given by the landlord to the tenant and ends on July 10th, 2021. The payment of the overdue rent must be in equal installments. Each installment must be paid on the same day the rent is due under the tenancy agreement. So if rent's due on the 1st, the payment amounts are also due on the 1st, in addition to the rent. And the date the first installment is due must be at least 30 days after the rent repayment plan is given by the landlord to the tenant. So these 4 terms can only be amended by the landlord and tenant together, and they can only be used to do things such as extending the repayment period beyond July 10th, 2021, allowing earlier installments to be less than later installments. For example, the tenant would pay $100 for December and $300 in January, but not vice versa. And they can change the date that the installments are due each month. For example, a landlord gives a tenant a repayment plan on September 1st. The earliest installment that is required would be October 1st, but the landlord and tenant decided that the first installment could be paid on the 15th instead, so they pushed it back. Okay, so repayment plans must be in writing and include the following. The day the repayment period starts, so this is the day the repayment plan is given by the landlord to the tenant. The total amount of rent or utilities that are overdue. So for example, a lump sum of $2,000. The date on which each installment must be paid. So like we previously said, if rent's due on the 1st, it should be paid on the 1st as well, unless mutually agreed otherwise. And the amount must be paid, that must be paid as each installment. So if we're using the example of $2,000, if we break that up over those months, it's going to be $200 each month. So landlords and tenants should use the form RTB 14 when issuing a repayment plan, because it does include all the required information and it's a little easier to fill as opposed to drafting your own. Now, a repayment plan must be given to a tenant in one of the following ways: either hand delivered, sent by registered mail to the address at which the tenant resides or the forwarding address provided by the tenant, or as ordered by an arbitrator on an application. There's more information about serving documents in Policy Guideline 12, which you can always refer to later. So another important change that has come from the pandemic is surrounding rent increases. The government has suspended rent increases until July 10th, 2021. If a landlord gave a rent increase before or during the pandemic, it will not take effect until July 10th, 2021 at the earliest. As always, tenants must be given 3 full calendar months notice on the approved form. So that form is RTB number 7 for residential tenancy units and RTB 11 for manufactured home park tenancy units. So the amount of the increase cannot exceed the amount permitted by law, which for 2021 is 1.4%. Landlords can only increase the rent once in a 12-month period. So going forward, if a notice was issued before the pandemic, taking effect, for example, January 1st, 2020, the next increase could not take effect on or after July 10th, 2021. Remember, it's not the day that the notice was issued, it's when it takes effect that you need to consider the percentage allowed. It is important to note here that if a landlord does collect the increased amount during the period that rent increases are not allowed, the tenant can deduct that amount from future payments. Okay, so evictions. The ban on issuing evictions for non-payment of rent was over on August 18th, 2020. This means that tenants must pay the rent in full on the day it is due, or they can be evicted. So for most cases, that would have been September 1st rent being due in full. As of that date, a landlord could issue a notice to tenancy for unpaid rent or utilities if the tenant failed to pay rent that was due before March 18th or fails to pay rent that was due after August 17th. So that could be March 1st rent, for example, or it could be September 1st rent. But all the stuff in the middle has to be done with a repayment plan. A landlord cannot issue a notice to tenancy for unpaid rent or utilities that came due during the period of March 18th to August 17th, unless the landlord has given the tenant a repayment plan for the unpaid amount and the tenant has defaulted on that repayment plan. A landlord cannot charge a late fee for any unpaid rent that was between that period of March 18th to August 17th, 2020. Late payment of rent and non-payment of rent during the specified period of March 18th to August 17th are not considered cause for eviction. So since RTB dispute resolution hearings are held mostly by phone, we've not stopped holding them during the pandemic. They have continued. However, there were some restrictions on how documents were served. The ban on personal service was lifted in August, and the director's order allowing for email service has since been rescinded. While Service BC and the Burnaby RTB office are currently open, their operations have been modified to ensure public safety. There is no in-person service at the office in Burnaby, the RTB office, and there's only access to a Dropbox to submit paper forms, access to public computers, or paper form pickup. With that in mind, parties are asked to stay home if possible and are encouraged to file applications and evidence online. And certainly they can call the information line to speak with an officer such as myself if assistance is required through that process. So the COVID-19 page on our website has all the latest updates. You'll want to check back regularly. You'll notice it's that sort of pinkish banner up at the top above that picture of the family. You're going to find the information about COVID updates, legislation changes. There should be some info sheets as well. And then further down on the homepage, there's links to all of our standard tenancy information. Okay, so I would encourage you to just check back, as frequently as you can to make sure you have the most up-to-date information, because information does change rather quickly nowadays. Okay, so that's it for me. I just wanted to leave our information here. This is our information line number if you wanted to take it down, 1-800-665-8779, and our hours are 9 a.m. to 4 p.m. Monday to Friday, and we're happy to answer any questions you might have.
Thank you so much, Erica. That was very informative. We will have questions at the end, everybody. Just to remind you, Erica as well as Carrie will be back on at the end to allow for your questions. So our next speaker is Carrie Rogers. Carrie's been with us before if you've been following the series. She is in-house counsel at High Street Accommodations. High Street's an industry award-winning corporate housing company with an inventory of more than 260 fully furnished, equipped, and serviced properties throughout the Lower Mainland. Every property in High Street's program is owned by private real estate investors who choose High Street for their ability to generate competitive return on investments and to maintain the property in beautiful condition. As High Street's in-house counsel, Carrie provides strategic guidance and advice to ensure that High Street successfully navigates the municipal and provincial legislations and regulations that affect our inventory and our industry. She's a regular speaker at regional and national events, including several with us for the Corporate Housing Providers Association. Carrie talks to real estate investors and their advisors about issues ranging from municipal and strata corporation bylaw interpretation to vacancy and spec tax compliance. She regularly meets with strata councils and property managers in support of High Street's community relations strategy. Before joining High Street, Carrie practiced commercial litigation and family law. She was called to the bar in 2011. Welcome, Carrie, and thanks again for joining us.
Hello, everyone. Darcy, thank you for that introduction. I miss not looking out over a podium and seeing everybody looking back up. And also that is definitely pre-pandemic Carrie on that screen there. Times have changed. Let's just start the screen sharing. Okay. Today, I'm going to be talking to you about best pandemic practices and the practical realities of renting during COVID-19. The goal of these best practices is to prevent problems, I guess, before you need to call your friendly RTB information officer. These are lessons that High Street learned the hard way in some cases. Sometimes we had good ideas that helped us ahead of the game. So let's dive in. Today, I'm going to go over the difference between cleaning and sanitization, physical distancing and PPE, how we do showings and inspections these days. I'm going to talk about one of our service promises that helps build trust and a sense of integrity in our client relationships. It makes everything so much easier. I'm going to talk about a few additional precautions that we're taking that help keep everything running smoothly. And I'm going to share some special issues in quarantine and self-isolation topics that we have encountered on our last 10 months together. So, cleaning and sanitization. There is a difference, and I want to talk about cleaning and sanitization a little bit because understanding the difference and being able to talk about sanitized property helps build a foundation of trust with our clients and our residents that we find just sets the stage and helps us deal with future requests and future access needs, like when we need to show the suite, when we need to attend for a maintenance issue, things like that. So what we've learned is that residential properties obviously contain hard and soft surfaces. Lysol is great, but what do you use or what can you use on fabric, wood, vinyl, plastic, and other surfaces that we find throughout our homes and properties? We quickly discovered that the BC Centre for Disease Control refers to Health Canada's list of hard surface disinfectants, which are proven effective against the coronavirus that causes COVID-19. But hard surface disinfectants cannot do the whole job. So we were left looking for soft surface products that give us the same degree of comfort and assurance. So that meant digging around on the Health Canada website, talking to our industry colleagues in the United States who are dealing with the United States Environmental Protection Agency, and a whole bunch of similar resources. In the early days, we were actually leaving properties vacant for 72 hours to allow the virus time to fall out of the air and expire. Now we've found sufficient cleaning products that allow us to clean and sanitize to a level of comfort and assurance that really just makes everything easier. So true sanitization is at least a two-step process, sometimes 3 steps. Cleaning refers to surface cleaning. That's the wiping away, the elimination of surface dust, dirt, and other particles. You can use soap and detergent as required. Step 2, or step 2.5, I guess, is the disinfection and sanitization. This is where you bring in that Health Canada approved product, meaning it is confirmed a viricide and a bactericide. You want to know that with proper application and technique, you can say that this product kills the coronavirus. High Street's product of choice is called Vital Oxide. It can be applied directly. It's good on hard surfaces. It's good on soft surfaces. There is an electrostatic spray application for large volume applications. And there's also an ultra low volume spray gun. We call it a mini fogger. And it is fantastic in smaller spaces. So that's what we're using for all of our properties. Vital Oxide is great. It's a viricide, it's a bactericide, it kills mold, it eliminates odor, it is Health Canada approved, it's approved with the United States Environmental Protection Agency. That I mentioned the EPA because we still get a fair number of cross-border clients, and they like that we're using an EPA approved product as well. It's non-irritating to skin, it's non-corrosive to treated surfaces, so we feel safe using it on truly everything in a home. And it's also effective against pet dander, dust mites, and other allergens. It is a wonder product. Yeah, that's cleaning versus sanitization. Being able to refer to our cleaning and sanitization processes basically every step of the way has created this foundation that just makes everything we do in our properties so much easier. Step 2 for us is physical distancing and personal protective equipment. So not just masks, but face shields and disposable nitrile gloves when necessary. Our teams go out equipped with the ultra low volume mini foggers as well. They're very portable and really easy to use. So if we're going out somewhere, we're wearing a mask. We live inside of hospitality and service delivery. At this point in the pandemic, wearing a mask, regardless of the regulations and our health orders, wearing a mask is perceived as the courteous, conscientious, and empathetic approach to getting through this pandemic. When we arrange viewings with our clients, we confirm that everybody present is going to be wearing a mask, and we're not afraid to make the request that if somebody says that they are exempt from wearing a mask, we ask that a non-exempt family member or colleague or somebody helpful can attend in their place. They can bring in their non-mask wearing family member or colleague by FaceTime or a WhatsApp video call or something similar. But anybody who's going to attend in person is going to be wearing a mask. Children under the age of 12 can stay home or wait outside, or yeah, that's our request. We make a point of one person in a property at a time. So if a property is vacant, it's already been cleaned and sanitized, including our fogging protocol. Our high street representative is wearing a mask and a fresh pair of disposable gloves. They're going to go in and set up the property for the showing, turn on all the lights, open all the blinds, adjust the thermostat, do whatever they need to do. Usually that means arriving at the property ahead of time. And we know what the property needs, so we know how much time to book. Then the agent leaves and lets the clients walk through by themselves. And at the end of all that, our person goes through and refogs the unit. So again, we know it's fully sanitized with that virus killing product. If the property is occupied, we have already educated our clients about exactly what's going to happen, how the place is going to be cleaned and sanitized. And we are doing our best to make that appointment as convenient for our clients as possible. Frankly, where necessary, we will incentivize them to leave the suite for a couple of hours with a gift card to something that makes it worth their while to just get out for a couple of hours. They know that when they return, the property is going to be exactly as they left it, and it's going to have been freshly sanitized. And then because our properties are investment properties, if an owner wants to sell a property, we do take some steps with notice of termination. We want it removed from our inventory, which means making it a fully vacant property before any intense sales-related activities are going to take place. So in this case, it does mean that some owners are waiting until the property comes vacant, but usually, they're still getting paid their rent during that period, and getting paid rent makes everything a little more tolerable. So this is our service promise. What you see is what you get. We want our clients to know that when they look at our media, our photos and our video tours and our virtual tours, that is absolutely the property that they are going to be moving into. And that can help minimize those in-person appointments. However, there are some things about properties that you just don't know until you are standing in the living room, you know, doing the full 360 stand and turn and see for yourself. I don't know what it is about downtown New Westminster. It's a total mystery to me why I can hear the trains in one location but not another. And if you time your video tour correctly or you use nice background music, nobody's going to know that you can hear the trains every 5 minutes. Hearing the trains every 5 minutes is definitely a deal breaker for some clients. And so it's just not going to work. Sometimes you just got to be there. A recent experience I had was, gee, that's a great view, but I can smell the municipal landfill from here. Also not something that's going to show up on a video tour. This comes down to, as you guys know, it's a trust relationship and integrity is everything. You cannot hide these things from your prospective clients. Think of it as a light version of a patent defect, meaning that the issue would reveal itself to a potential tenant or client who has a reasonable opportunity to view the property in person. When our clients are unable to view a property in person before moving in, we have that service guarantee. Our clients have to be able to trust us, as I'm sure you know. Oh, this is the part in the slide deck where I got tired of virus-related imagery and I started thinking about where I'd like to be instead. These are the additional precautions that we are taking, mainly with respect to the fact that there was a period of time where certain people simply stopped paying rent. There are now solutions to that conundrum, but the preference always is to prevent a problem before it arises, and we can do that in large part by checking references. So we check references by obtaining written authorization to complete a rental employment and background check. Landlords can't charge fees for any of these background checks with reference to Section 15 of the Residential Tenancy Act. But we include a statement in our application to the effect that our tenants acknowledge that the information they provide to us is true and correct to the best of their knowledge, so that we have a little extra protection maybe later on if it comes to light that perhaps fraudulent information was provided in that application. The Office of the Information and Privacy Commissioner of British Columbia has a very handy and helpful guidance document for landlords and tenants. In particular, landlords, it will help you use the correct language in obtaining your prospective tenant's consent to do that reference check. You need that correct language because that reference check requires gathering and using certain personal information that engages our provincial privacy statute, PIPA. On a similar scale, corporate reference checks are also a thing. If you have a corporate tenant, you can check their references as well. And then the other precaution that has always helped us out is that if a rental property is a strata lot, we make it a written term of the tenancy agreement that tenants are responsible for paying fines and remediation costs for contraventions of bylaws or rules that take place in that strata community. All right, this is my last piece today. Special issues. Quarantine and self-isolation in shared and common spaces, rental buildings and strata corporations. Some of these issues have truly stumped us. I definitely don't have all the answers right now. I have been skimming the question box and I already see that I'm not alone here. You have also been stumped by some things that have occurred in the last 10 months. And it's nice to not feel alone. So here's some things that have happened. There's a notice in the elevator or the common area that there's a confirmed case of COVID in the building, and now my tenant wants to break the lease and move out. That's a thing. The tenant needs to quarantine for 2 weeks, But the strata corporation bylaws require that owners, tenants, and occupants meet their delivery people at the front door, in the lobby, or outside of the building. Basically, delivery to the door of the suite is prohibited, which makes it impossible for these residents to get their groceries delivered, and everything else that is suggested you do to manage your quarantine period. You're quarantined and you're new in the building, so making friends with a neighbor and asking them to grab your delivery from the front door is not super realistic. And then lastly, we have a lot of people who phone us and ask us, is it okay that they take out their garbage and recycling while they're stuck at home in their quarantine period? The answer is, I think yes. Put on your mask, put on your gloves, take your garbage down to your building's garbage room. That shouldn't be a violation of your quarantine requirements. So that's what I've got today. Thank you very much. As always, I am sharing best practices. If you need legal advice, that's a whole other thing. But we're in this together, so thank you.
Thanks so much, Carrie, as usual. Fabulous presentation. And thank you again to Erica for your presentation. We're now going to move into our Q&A period. We do have a number of questions queued up already for our panelists. But for the rest of you, if you do have questions, please remember to submit them. There is a little Q&A button at the bottom of your screen. If you look at it now, it'll show that there are questions in the queue. And we will get to as many of them as we can. I can't guarantee that we'll be able to answer them all today, but I do know that our events team does collect these questions, and they often send them out to us later to try to get some answers back to you guys and make them available to you any way we can. On another note, you can always call, especially the folks from RTB, but do be patient. Be aware that there's a million people in British Columbia that are also there to ask them questions. So if we can get all three of our guests back on camera. There's Josh, for those of you that, well, we haven't seen Josh yet, but there's Josh from the residential tenancy branch. Erica's back, and there's Carrie as well. So I'm just going to go through questions, and if I think they're for a specific person, obviously I'll direct it to the appropriate person. Otherwise, I'll just leave it open to the three of you to jump in and make your comments as you feel fit. So first question, I'm not sure anybody can answer this, but maybe Carrie. And that is, are rent increase protections only for residential tenancies, or do they apply to commercial tenancies as well?
That's a great question. Today's presentation is focusing on residential properties. No, there's been no provincial intervention in commercial tenancy agreements. There's commercial rent relief provisions out there. It'll be the commercial tenancy agreement that governs rents paid. There are commercial landlord resources out there, but just generally speaking, no, everything we've talked about today is for residential properties.
Thanks, Carrie. I know that was an off-topic question, but I thought you being the lawyer, you'd probably have the best answer. Okay, next question is for our RTB guests. Does the repayment plan have to be, the agreement have to be on the RTB provided form?
Great question. So actually the COVID-19 regulations for the Residential Tenancy Act and the Manufactured Home Park Tenancy Act doesn't provide that the repayment plan has to be on an approved form. However, there are very strict requirements as far as the information that is on there. So we do have a template on our website with regards to a repayment plan form that you can use. So that being said, if you choose to come up with your own repayment plan, just be very careful about making sure that all of the required information is there. Otherwise, it could be deemed invalid if you end up having to use that as the basis for an eviction. So, to be safe, maybe take a look at our repayment plan template, but no, there is no actual requirement for it to be used on an approved form.
But just to be clear, there is a requirement that certain information is in that agreement.
That's exactly right. Yeah.
Okay. Thanks so much, Josh.
And the RTB form does include all that information, so we would encourage the use of that for sure. But like Josh said, it's not actually mandated.
Perfect. Next question. This is probably an all three of you question. Is it legal to require tenants to have a tenant's insurance policy? And if so, is failure to have that policy grounds for eviction?
So I can certainly...
Go ahead. Actually, Erica, you could take first crack at this.
Sure. So essentially, landlords can put that as a term in an addendum to a tenancy agreement that they wish that the tenant has tenant's insurance. And then if that is viewed as a material term of the agreement, then it could be grounds potentially for a 1-month notice and tenancy for breaching that agreement, provided the landlord did write them a warning letter first saying, hey, get the insurance by this day. Failure to do so could result in the 1-month notice.
May I add a little to that?
Of course you can.
So most tenants insurance just covers tenants' contents. If you want your tenants insurance to cover property that you own, you need to be really specific about that.
Yes, and many times, as you said, it only covers their contents and doesn't cover any kind of liability that they might have. So for those of you that are tenants or landlords out there, you should really look at insurance because it does cover a lot more than just your belongings, which you may not place a high value on. Next question up. This is for Carrie. And by the way, Carrie gave some great tips for anybody that's out there that's a landlord, seeing how High Street does things, to that next level as a business. That's good advice for a lot of landlords that may not be as sophisticated, but the level of sanitation and care and even the way they present the properties is something that anybody that's a landlord themselves can certainly learn from. So the question is pretty simply, what is the spelling of this Health Canada approved sanitizer that you use?
Vital oxide. It's spelled VITAL OXIDE. It is available. It's available in a couple of different ways. Separately, the low volume fogging device that I talked about, that's called the version we use is called a Cobalt Mini. I will share all of this in detail. Like, my contact information is out there. You guys are welcome to email me. I will connect you with the supplier. I can connect you with the people who can do the cleaning. Like, I will connect you, absolutely.
Just a warning, Carrie, we have 424 participants on this call right now, so you might get a lot of emails.
I'm ready. I'm totally ready. Bring it on.
She says, bring it, guys. Everybody email her today. Load up her inbox. Okay, next question up is, after a tenant-occupied property is sold and prior to completion in possession for the new owner, if a contract stipulates that a buyer is allowed access for measurements with notice, can the tenant refuse access due to COVID? This is a different version of a question that we've had a million times, but who wants to take first stab at it?
I could take first crack. So with regards to this, the COVID-19 regulations don't really dictate too much beyond what it had already said about landlords' access. So there isn't anything too new with regards to you being able to access the rental unit in case of a sale or anything like that, from even pre-pandemic. Before the pandemic and even now, if you are able to give the tenant at least 24 hours written notice to enter the rental unit, you do have a right to do so. And so if in this case, the buyer, or the current landlord needs to make measurements and obviously you need to enter the rental unit to do so. 24-hour notice is what is required by the Act. Though of course the Act doesn't really go into the subtle nuances of trying to work together to see what could work best for everyone involved. So, that being said, if you give 24-hour notice, that is all that's required by the Act. Though of course we try to encourage everyone to see what works best, especially during this time.
Anybody else have any comments?
I mean, sort of just to echo that, essentially, if there is an update that suddenly says no landlords can go into a unit, that information would be published on our website under the COVID-19 section. So if there's some sort of legislative change that comes into play, obviously our answers might change. But certainly keep checking our website, give our info line a call. We're happy to help and answer that at that time.
Yeah,
Awesome.
Exactly. And honestly, I think a lot of, as everyone knows, there's been a lot of changes very recently. And things continuously change and evolve. So, not to keep promoting, just keeping an eye out on our website or anything like that. But really, even if it's not exactly Residential Tenancy Act related, we do keep updating things with guidance from the public health officer on our website, because that continues to change on a daily basis. So keep an eye out. But for now, at least, what we could provide is 24-hour notice is what's required.
Yeah, and the other thing that I would add to that is, the human courtesy element does come into play always with residential tenancies. If you're a buyer of a tenant-occupied property and you're planning on keeping that tenant, there is a measure of courtesy required to keep them happy and keep them paying rent. Because as a new landlord taking possession of a property, when you have an unhappy tenant at the start because they feel that they were treated unfairly by you before you took possession of the property, caution is always in order in that regard. So we'll move to the next question. What is the landlord's responsibility to repair? This is a pretty general RTB question. For example, a doorknob stops working. Does the landlord have a responsibility to repair things in a rental unit?
So I'll take a stab at that first, if you'd like. But essentially, the landlord has an obligation to maintain the unit in a manner that meets health and safety standards. So specifically to the doorknob situation, if that defective doorknob, for example, has the lock in it, and that's a defective lock, then the landlord is absolutely required to have that repaired if it's granting access to the rental unit. If it's a doorknob that's like a bedroom door kind of thing inside the unit, the landlord, like if the tenant's requesting that repair be done, and if they can somehow quantify that the loss of that repair has now created a loss for them of some sort, then the tenant could potentially file against the landlord for compensation equivalent to that amount. Now, is that likely? I don't know. I'm not going to put a statement out there saying no, landlords don't have to repair doorknobs, because if a tenant's requesting a repair, the landlord should be making every effort to make that necessary repair, or at least communicate back if, for example, the repair is extravagant or they're asking for something that's not within the standard scope.
So simply put, if it's a doorknob that's on an exterior door that's access and security, it's likely they do have an obligation to repair. Other than that, it's just common courtesy again. As Dr. Bonnie says, be kind. Next question is for Carrie. From Carrie's presentation, what is the source of the place investors we can help on language to use for lease agreements again?
The resource that I referenced in my presentation is a guideline document published by the Office of the Information and Privacy Commissioner. I will share it with Cheryl so that when you guys get your copies of this presentation and material afterwards, that that link and that guideline are easily available.
Thank you, Carrie. Okay, next up, what steps can a landlord take if tenants are simply refusing access for showings, having been given proper notice? We've had this question in previous sessions, but Carrie remembers it probably. But for Josh and Erica, what's your advice if a tenant refuses access?
Yeah, that's obviously a tough situation to be involved in, and I think generally speaking, you know, the last option that you always want to try to take is through dispute resolution. I think if all efforts to try to work together simply don't work or fail with this tenant refusing to allow access to the rental unit even after proper 24-hour written notice is provided, then really I think the next steps for you as the landlord or the landlord's representative would end up being really dispute resolution through the residential tenancy branch. Now, mind you, of course, you know, dispute resolution, we can always provide assistance through that way, but that obviously doesn't get you the access you need immediately. I think even talking to the tenant, letting them know refusing access to the rental unit could be grounds for a 1-month notice, might be enough also to inform them that, you know, you have a right to enter the rental unit with this 24-hour notice. So, you know, just informing them, letting them know maybe to reach out to the residential tenancy branch just to get them to be informed could hopefully avoid that dispute resolution process. But ultimately, even if that fails, then you do have the last option to file dispute resolution. Again, you know, we try to encourage people to try to work together, just be informed. Maybe the tenant just doesn't know their rights and obligations as far as landlord's access is concerned. So, you know, if you can't get through to them, maybe direct them to contact the RTB. An information officer could let them know that they're, you know, they obviously can't refuse access like that. So especially if you're giving 24-hour notice. So that's always an option, just to direct them to our website or our information services line as well.
From our perspective, this is the velvet glove and iron fist approach. The iron fist being we are 100% clear on our residential tenancy rights and that 24-hour notice to access, it is what it is. The velvet glove is the, you know, the sanitization, the gift card, not to be too mercenary about it, but I'll be very mercenary and just say that everybody has a price. And there is a number out there that will make it worthwhile for that tenant to go somewhere else and be busy somewhere else for a couple of hours while you do what you need to do. For High Street, the most expensive was a $200 gift card to a nice restaurant in Gastown. That worked.
Yeah, sometimes you have to negotiate to get the hostages free. I'll just add something that, as a practice point, just from my own experience as a realtor, this problem is often solved before the property's listed. So for you guys that are working with sellers of tenant-occupied properties, I always ask to have a meeting with the tenants before the property goes on the market and just explain to them, these are the procedures we're going to follow for showings. We're going to try not to inconvenience you. If you have specific requirements, please tell me now if there's certain days and times that just don't work for showings, or if we want to agree that showings will only be on certain days at certain times. If you have that conversation up front with the tenants, you can eliminate virtually all of these issues where they go, oh, I don't want a showing on that day. You can just go, well, you agreed that these were the days, so this is what we're doing. And as Carrie said, you know, a little grease goes a long way. You can often, with a simple Starbucks card, every time there's a showing, say, hey, you know, it's Starbucks time, off you go. Here's a $20 Starbucks card, and you can go have a coffee and a scone, and come back in an hour, kind of thing. So that's my advice on that one. Next question is there a form in the government site for a mutual agreement to end tenancy? That's a pretty simple answer for that one, but I'll let Josh go for that.
Yeah, we do have a form for mutual agreement to end tenancy. I think we could probably provide Cheryl the link to that as well if you guys need. But if you just do a search on our website, we do have a template for that. So definitely give it a shot. Otherwise, we could provide the link to Cheryl, but we do have a template for that form.
Yeah, on the RTV website, there's actually a forms link that takes you to all of the tenancy forms that are provided. They're named and numbered kind of odd, but once you go through it a couple times, you kind of see, oh, in this case, it's actually called a mutual agreement to end tenancy. So it's an easy one to find. Next question up is, after a fixed tenancy ends, can a new fixed tenancy take place if both parties agree? Is this okay with RTB?
Yeah, so if one fixed term lease ends and the landlord and tenant agree that, yeah, they want to sign for another year or another fixed period, they certainly can do that. But I would caution that rent increase provisions, so like if we remove COVID for a second, rent increase provisions would apply still because it's the same tenant in the same unit, regardless if it's back-to-back fixed terms. So the landlord, if they wanted to increase the rent, they couldn't just bump it up on the new agreement. They would still have to serve the proper notice of rent increase. So COVID times, because rent increases are not a thing right now, it's just if you want to do back-to-back fixed terms, you're welcome to do that if both parties agree.
Right, and if there is, when you're negotiating that fixed term, if you're doing it 3 months ahead of time, which is a good practice recommendation, if you're doing it 3 months ahead of time, you can give notice of a rent increase, but it won't take effect until July 2021.
That would be the case. Now, I would also say as well, like we don't know what changes might come. So all the info we have is up till July of next year, as far as restrictions on rent increases. But if things change, again, always call us, check our website. That's where the most up-to-date info is going to be for that.
Perfect. Okay, next question. Does a tenant have the right to negotiate compensation for leaving the unit when seller already provides 2 full months notice after the unit is sold firm? So this is a case of a sale of a unit. The tenant's given 2 months notice because the new owner is going to use the property for their own use. Does the tenant have the right to negotiate compensation for leaving under that notice?
That's an interesting question. And I mean, the legislation just mandates that they get 1 month rent compensation when given one of those 2 month notices for landlord's use. But I mean, that's what the legislation requires them to do, or to at least receive. If you guys are willing to work together to give more, that's ultimately up to you. But really, the tenant only has the right to dispute the notice if they don't believe that the notice is given in good faith, or whether the landlord is using that property according to the notice or the reason stated on the notice. They can't dispute it because they want more rent or more compensation. That's not within the provisions. If they accept the notice, they get the 1 month compensation, and that's really what the legislation requires. There's nothing obviously beyond that that says you can negotiate anything beyond what's on the legislation. That I think that would be mutually agreed upon between the parties involved. But the legislation is pretty clear that they get 1 month, and that's at least required.
So there's nothing to stop them from trying to negotiate, but under the legislation, they're entitled to 1 month and not more.
That's right.
Okay, perfect. Next question. If the rental property is sold in December 2020 and the tenancy agreement is a fixed term until September 2021, and the tenant insists to stay till September, it says 2029. Don't know if that's a typo. when and who should serve the notice to end tenancy. So if the tenancy ends at the end of September 2021, when would notice have to be served if the new owner wants that tenant to move out at the end of their fixed term?
So essentially a 2-month notice can be served in advance. However, it can't end a fixed term early. So if the fixed term here, the property changes hands, new owner wants to move in, they serve a 2-month notice, assuming that the rent is due on the 1st in this circumstance, and the tenancy ends at the end of September of next year, then they would have month of September, month of August. So the 2-month notice would have to be served in July of next year. And the way it works with a fixed term, it's actually a little bit different as far as the compensation goes, because the tenant, what the notice says is that the tenant is entitled to the 1 month of free rent on or before the effective move out day of the notice. So what that means is the landlord is required to compensate the tenant the 1 month of free rent by the effective move out day on the notice. Now with a fixed term agreement, essentially the tenant is saying they agree to stay in the unit and pay the rent for the full term. So that would mean that with a fixed term, it's not like a month to month in that the tenant would be required to pay their last month of rent. However, the landlord would have to pay that back to them at the end of that fixed term. So oftentimes landlords are just like, hey, just hold your last month of rent, it's cool. But sometimes they're not, but the landlord still has to compensate that amount.
That's a great answer. And often the question becomes, if it's a fixed term tenancy and they're supposed to move out at that time anyway, based on the tenancy agreement, is the 1 month compensation still required? And you answered that without really answering it, but the answer is yes. It's yes. If you give them notice to end the tenancy at the end of the fixed term, you still have to pay them the 1 month.
That's right. And something to think about as well is that fixed term agreements, there's only 2 circumstances where the fixed term truly means the tenant's got to move out at the end of the term. And the first one is if the landlord was occupying the space and that was written into the agreement at the time it was signed. However, with the property changing hands, I don't know that that would be a valid vacate clause because it's a new owner. So how could they have known they were going to move in at the time the agreement was signed if it was owned by somebody else, or it was a sublet agreement? So either way, the tenancy would likely continue month to month at the end of that September term, unless both parties signed a new fixed term agreement.
Right. But the new owner has the right to deliver 2 months notice ahead of the end of the fixed term if they're planning to use the property themselves. So part 2 of that question was, who gives that notice to end the tenancy at the end of September? If the current landlord is the owner now until the end of January, could they still give the notice that far in advance that that tenancy is ending because the new owner is going to use it for their own use?
Yeah, I mean, there's nothing stopping them from serving. If the new owner writes a letter to the current owner, says, hey, please serve the 2-month notice on my behalf on December 15th, let's say it completes, or it already completed, and that they're now willing to serve that. It depends on which box is checked on the 2-month notice. Because on page 2 of that notice, box number 1 is that the current owner wants to move in, and box number 3 is that the new owner wants to move in, and they've written a letter to the current owner to serve the notice on their behalf. So it's a matter of who is the landlord at the time the notice is served, and the purchaser information does need to be included on that 2-month notice as well.
Perfect. That's exactly the answer I was hoping you were going to give. Well done. Next question. Does July 10th automatically become the new anniversary for rent increases?
Yeah, I could take a crack at answering this. It essentially does, because what really happens is that the rent increase notice, the effective date is essentially moved at earliest July 10th, 2021. Now, obviously, the actual new rent increase anniversary will depend on when the tenant usually pays rent. So, that just because the earliest effective date of that notice of rent increase becomes July 10th, 2021, doesn't mean the tenant is now paying on July 11th or July 10th, right? If they pay rent on the 1st, I assume that August 1st, 2021 will be their first increased rent amount. And rent increase provisions require at least 12 months between rent increases. So if you do want to increase the rent again, the earliest would be August 1st, 2022. But I think with regards to maybe jumping ahead a little bit, just keep an eye out with regards to any news with the rent increases. But generally speaking, I think the effective earliest date of any notice of rent increases that have been issued or are currently outstanding would move to July 10th, 2021. And yeah, as I mentioned earlier, you just have to keep an eye out for when the tenant really pays rent, because that'll be their new, essentially their new anniversary date for rent increases.
Thank you. And most tenancies rents due on the 1st, so excellent answer for that one. What if a tenant's supposed to vacate at the end of the month and they end up having to go into quarantine? Do they still have to move out?
That's a very interesting question, because it's not something that's actually covered in our legislative changes. So unfortunately, I mean, we don't really have an answer for that. I can't say that somebody's got to go or not go. According to our legislation, tenancy ends at 1 p.m. on the day before the rent is due, so the last day in the rental period. That being said, maybe that's a circumstance where the person should call the public health office and see if there's any direction for them as far as somewhere safe that they can go if they don't have somewhere to go at that time.
Okay, any other comments, Carrie?
Ends of tenancies and moving out doesn't occur as a surprise. So even if you've suddenly tested positive and you need to quarantine, my first question would be, why can't you quarantine in your new residence?
That's a good lawyer answer. I like that. So the rules are still the rules. Nothing's changed that specifically protects a tenant from moving out if they have to quarantine. If they were on vacation, they just came back from out of the country because they were traveling for whatever reason, and they're required to quarantine, or they're required to self-isolate under contract tracing order. Why can't they quarantine in their new residence? That's a very good answer. What is classified as appropriate written notice right now during the pandemic to a tenant? So written notice requirements, are they any different now, or what are they during this COVID mess?
Yeah, so generally speaking, with regards to written notices, I think the general guideline we provide is it should be on paper, served under one of the prescribed methods under legislation. And that's usually like in person, posting it on the door, sending it registered mail. Of course, if you're not serving it in person, you kind of add deemed received dates, and not to complicate the matter any further, but that essentially elongates the 24-hour notice period. For example, if you serve something by posting it on the door, it's deemed received 3 days later, and then 24-hour notice on top. So, you actually you need to post the notice a lot earlier, actually, than 24 hours ahead. So, just those things to keep in mind. There aren't any additional methods of service at this time based on the pandemic. With regards to email, I think, it's not currently an approved method of service. So unless you apply for a substituted service substituted service order through the residential tenancy branch, and you sort of prove that you serve things normally through email, and you can prove that the tenant will be in receipt of that, you're sort of taking a risk by serving it by email. So I would generally say stick to the currently mandated methods of service if you want to play it safe.
So 24 hours notice applies if notice is delivered in person and you can verify that the tenant received that notice at that time.
Yeah, I mean, if you give it in person, I think you're pretty safe. for a time, I believe, prevented or at least banned in-person service at the beginning of the pandemic. And at that time as well, we allowed for email service through a director's order. Now we had rescinded that director's order. We had rescinded that ban of in-person service. You're allowed to serve in person again. So yeah, you could serve in person. It's pretty easy to prove service if that's the case. And if you have any doubt, you might want to have a friend with you as a witness when serving a notice in person.
That's actually great advice for any service of any kind of notice to a tenant, to have someone else in attendance. And if it's the case where you're an agent acting for the landlord, having the landlord personally serve the notice and you in attendance with them, so you're both there, is often a good idea. And if it's not possible for you as the agent for the landlord to have a witness so you can verify time and place when the notice was served, is a great idea. Okay, the next question. If a new tenancy agreement was signed and it was to have a new rental amount starting April 1st, 2020, is this new rent effective on the date of the start of the new tenancy? Or should the previous rent remain the same as it was before April 1st? So assuming it's the same tenant with a new tenancy agreement, and the new tenancy agreement was in effect April 1st. So what rent do they pay, and when would the increase be effective?
So ultimately, like we talked about previously with back-to-back fixed terms, the rent increase provision still applies. So in this circumstance, the landlord would have had to serve the 3-month notice in advance of that. And keep in mind that the rent increases were put on hold from April onwards. So that means that right now, that person is likely to be paying the March rent. And they are allowed to continue doing so until rent increases are permitted. So as of right now, perhaps August 1st would be the first, assuming it's the rent's due on the 1st of the month.
I would also add, if you are looking for any written guidance with respect to that, our policy guidelines 30 and 37 also speak to that same question. I believe 30 is speaking directly to fixed term tenancies, and in this case, back-to-back fixed terms with a rent increase in between with the same tenant. 37 is about rent increases and about mutual agreements to increase rent. So, if you're looking for something written regarding that topic, those are good resources to have as well.
Great, thank you for that. Next question. I had a case where we had a tenancy agreement disallowing pets, but later the tenant got a pet without permission from the landlord. And when this was discovered, the tenant offered to pay extra rent for the pet. The landlord agreed, but later made an amendment to the agreement accordingly. Later, we submitted this case to the residential tenancy office for not paying rent, but the RTO looked for a notice of rent increase and denied this increase. Is this proper?
I would really say that ultimately, with regards to trying to answer very fact-specific questions on disputes, it's sort of inappropriate for us to try to respond to that without knowing exactly what happened in each case. So I would love to answer this, Darcy, but I don't know if I really can. Because ultimately, I think it would really determine on what facts are before the arbitrator, and they would have to make their decision based on those facts. So hard for me to say.
Yeah, it becomes one of those tricky things when it goes to arbitration, what the actual facts of the case are. But in essence, if there is a rent increase, regardless of whether it's an agreement for changing either the premises of the tenancy or adding a pet or a person into the tenancy, if the original tenancy agreement didn't allow for that, if it's fixed to this number of people and this number of pets, and if we add that person or pet, then the rent increases by X amount. My belief would be that you still have to give that 3 months notice to increase the rent, and it wouldn't be effective right now if we're talking about the current environment.
Yeah, that's exactly right. And I mean, general best practices, or something I imagine most information officers would provide guidance on, is just to make sure everything is recorded on paper. Just have documentation of whatever you agree to, because ultimately, whether you go to dispute resolution down the road or not, it's just a good idea to have something to record what had been agreed upon between the parties. And I'm sure Carrie would attest to that, and be supportive to that sort of guidance. So yeah, just have everything in writing.
I know Carrie's advice would be read the contract, because that's what we always hear from the lawyers. What does the contract say? Okay, awesome. Erica, can you please repeat the provincial allowable rent increase percentage for 2021? Do we know that yet?
We do, yes. So it's 1.4% as of right now. That's the allowed amount for next year, 1.4%. And that, again, July 10th is the magic day. Anything after that, as of right now, is what we're looking at.
Okay, 1.4%. Duly noted. Next question. The building where I've a listing is restricting visitors and realtors. This has resulted in the tenant informing me that she will not allow showings due to this new notice that has been posted in the building elevators. I contacted the property management company, and they said this was implemented by the Strata Council. They forwarded my inquiry to the Strata Council 2 weeks ago and have not heard back. Is this allowed? Can a building have a restriction on visitors? I don't know if this really is something that any of us can really answer right now, but maybe Carrie.
So my first question would be, how did the Strata Council make this happen? So bylaws have to go through the usual procedure at an annual general meeting or a special general meeting. My guess is that the Strata Corporation has made a rule. Strata councils can make rules basically anytime they want. On an annual basis, rules do have to be ratified at annual general meetings. But let's go on the basis that this is an ad hoc rule that has been passed at somebody's, Tuesday night Strata Council meeting a couple of months ago. Strata corporations can make rules governing the use, safety, and condition of the common property and common assets, but they can't make rules about your private strata lot. So unfortunately, you're running into this awful gray area. They can deal with visitors and occupants and tenants in the common area and common property, but they have no business making rules that apply within the strata lot. If I were involved in this situation, I would be requiring a meeting with the Strata Council under the Strata Property Act. Aside from the usual attending to respond to a bylaw or rule infraction, you can request attendance at a council meeting. It's section 34.1 of the Strata Property Act. You can make an application in writing requesting a hearing at a council meeting, and they have to grant you that hearing within 4 weeks of that request. So I would start by getting myself in front of that Strata Council. It's probably going to be a Zoom meeting, and I would just have that conversation with them. The difficult thing here is that most Strata councils are not going to be super thrilled with this request, and they're probably going to stretch out that within 4-week requirement to the best of their ability. But that would be the start of a remedy.
Excellent. Thank you, Carrie. There's your strata law background coming back to save the day.
A little bit.
Perfect. Okay, next question up is how do we address a scenario of a tenant who's constantly complaining about some areas of the flooring squeaking? There's spots under the carpeting in bedrooms and under random spots under laminate flooring, the floor squeaking. in a rental unit that's approximately 5 years old, the landlord states the rental needs to be vacant to address this, as all the flooring would need to be removed. The tenant does not want to be inconvenienced, nor move out to allow for the repair. What do you do? Anybody?
Well, that's a tough one. Oh, Erica's unmuted herself. She can go.
Josh, did you want to answer this one, or shall I?
I mean, that's a little tough. Understandably, you know, the tenant has to understand that there's going to be, I guess, some wear and tear with the unit, especially if it's only 5 years old. I mean, a little bit of squeaking is, you know, something arguably that they could complain about. Now, you know, whether that's something that it requires a repair, and if they're really demanding that repair, you know, as a landlord, ultimately you have to sort of determine if that repair is so urgent, or is so important that requires, you know, vacant possession, because ultimately vacant possession is something that you really have to be careful around, especially, you know, when it comes to, you know, the period of time you require vacant possession, as ultimately it could also be a reason to end the tenancy. So I you know, this is a little bit tough to try to work around if nobody is looking to work together on it. But if the tenant really finds this to be an issue, this is sort of where, you know, I would kind of refer to where Carrie is talking about the velvet glove thing. If you guys can work out some sort of mutual agreement where they can move out for a period of time temporarily, and then you could make that repair, then, you know, maybe they'll be happy when they have a quiet unit with no squeaks. I don't know how reasonable that could be, but, you know, in the end, if they really refuse to do anything like that to work together with you, and they are so inconvenienced that they have to take it to dispute resolution, then, you know, perhaps an arbitrator can make a finding of fact about whether this sort of demand for this repair on these squeaks is reasonable or not. And so, you know, in that case, at least you've done what you can to try to work together with your tenant to resolve the issue. And then, as I mentioned earlier, if you have something in writing, you have record of your communication between each other to try to work it out, then perhaps, you know, you could show that you've done your due diligence. But in this case, it's sort of tough to see, or at least to try to answer without knowing how willing the tenant is to working together with you on, you know, a mutual agreement, or a mutually beneficial agreement between you two. So, you know, that's the best guidance I could provide within the confines of our act. This is something that, you know, you could try to work together with your tenant as best as you can. But if it really requires vacant possession, sometimes those things, if it requires a long time, might lead to might need, you know, the tenancy to end, or at least work together with the tenant to get out of there for a temporary period. So they have, you know, there's a little bit of bend for both parties here, and you guys have to sort of work together as best as you can. But if you can't, you know, do what you can to protect yourself if it goes through dispute resolution.
Yeah, the one piece of real good advice I heard there is document your communications. As a landlord or as a tenant, make sure you're documenting the communications with the other party, because if you're not and it does go to dispute resolution, you do not have much of a chance, particularly if one party has and the other hasn't. Next question. If the landlord gives notice and wants family member to move in, but changes their mind and re-rents the unit, is there cause for compensation for the tenant who's given notice to move out? The landlord has decided they're going to use the rental unit for their family. The family changes their mind. What happens next? Can they rent it out, or are they going to be required to pay the compensation to the tenant?
So ultimately, it's dependent on the reason why that person is no longer following through with their intent to move into the unit. for example, if we have a circumstance where somebody is having their parent move from somewhere else, and that's why they serve the 2-month notice, but now that parent, for some, maybe they passed away, and that's the reason that they can no longer move in. If it's something like that, there are extenuating circumstances which may remove the landlord's obligation to pay that compensation. But if it was straight up like they just changed their mind, they want to stay in their house kind of thing, and they turn around, the landlord turns around and re-rents the suite, then that would open themselves up to the compensation of 12 months of rent to the tenant for giving the notice in bad faith.
So it really comes down to proper notice given in good faith and being able to show evidence that it was in fact in good faith and there's a legitimate reason not to follow through.
Yeah, that's exactly right. I would really emphasize the extenuating circumstances bit that Erica mentioned. You know, I think simply changing your mind doesn't excuse you from that 12-month compensation. If you end up using the unit for a different reason than what you ended the tenancy, you know, extenuating circumstances is, you know, if the person that you or your family member that you intended to have moved in had passed away or something, then that's, you know, that's extenuating circumstances. But if they simply just didn't like the fact that there's not enough light in the unit or something and they don't want to move in anymore, that's not it. So just a caution with regards to that. Awesome.
Next question. This is kind of an interesting one, maybe one for Carrie to take a shot at. Is it legal to mutually agree on tiered rent for a prime furnished unit before entering into a tenancy agreement? For example, a lower rent during the winter months and a higher rent during spring and summer.
Can you repeat the first part of that?
Is it legal to have a mutually agreed tiered rent system for it says a prime furnished unit before entering into a tenancy agreement? So is it okay to have a tenancy agreement that outlines that during the winter months, the rent is X, and during the spring and summer months, it's a higher number?
So the way High Street does it is we, you know, rent is agreed upon in advance, and if we do tend to charge a higher rent in the summertime. Summer 2020 was a whole other thing. We give notice that rent is going to increase in time for the summer, and we follow the rent notice procedure. I've never tried a tiered rent agreement. So the question of whether it's legal, I would ask Josh and Erica if they've ever seen something like that from their perspective.
I personally haven't, to be honest, and I believe should it go to dispute resolution and the tenant disputes, you know, whether that proper notice is given and whether that follows the rent increase provisions, it would be hard for me to say that it would be fine, to be honest. I think that sort of agreement sort of bypasses or attempts to contract out of the rent increase provisions, and there's a likely chance that an arbitrator may find that to be the case, that you're trying to contravene the act and the rent increase provisions.
Okay, tough one to answer. I don't think I've ever seen that either. In 22 years of my practice, I've never seen a situation where there was a fixed term tenancy where, unless it was short-term rentals, short-term different situation entirely, they tend to be higher rent, as Carrie said, in certain seasons. But you know, if it's a 1-year tenancy agreement where there's higher rent during a period, never seen that. So is it possible? Probably. I would suggest, as you know, if you talk to your managing broker, what they're going to suggest is refer both parties to lawyers for legal advice on whether it's actually an enforceable agreement or not. Next question up, and we're close to the end of our time, so we'll probably try to do 2 more questions before we wrap up. If a tenant pays rent electronically by bank transfer, is a request by a tenant requiring a written receipt something a landlord must comply with? There's nothing in the signed tenancy agreement stating such would be delivered. can the same tenant then insist to pay rent by cash during COVID and they were paying electronically previously? So can they change the method by which they pay rent? And is there a requirement for them to get a receipt for their rent payment?
Sure. So all rent paid in cash, the landlord is obligated under the Act to provide a receipt for that. That being said, if it says in the, like typically the method of how rent is to be paid is something that's determined in the tenancy agreement. So you can put that in there, like saying e-transfers only to this email address kind of thing. And something with e-transfers, like you get an automatic receipt for that. So there's nothing in legislation that obligates a landlord to provide a receipt unless the rent is paid in cash.
So if the rent is paid in cash, you are required to provide a receipt. And if it's paid by e-transfer, there shouldn't even be a request for them asking for a receipt because they automatically get a confirmation when they send the e-transfer and also when it's deposited. So they get a receipt anyway. Okay, last question, and then we're going to wrap up. If we request the tenant to pay for a portion of the utilities not originally written in the tenancy agreement, is that considered a rent increase, thus 3 months notice needed to be given, or can we only increase by the 1.4% allowed?
So that would ultimately depend on, so that sounds to me like an amendment to a tenancy agreement. If, let's say the tenancy agreement included terms for $1,200 of rent with utilities included, and then you guys look to amend the tenancy agreement so that it's, changed to $1,000 flat rent with only with the tenant paying a portion of the utilities. That sounds to me like a mutual agreement to change the terms of the tenancy agreement. So you'd have to really look into ultimately the amendment provisions for changing the tenancy agreement. Now, if you remove or I guess ultimately remove or restrict services or facilities that were included in a tenancy agreement, there are provisions that require a landlord to reduce the amount of rent paid in respect to, the services or facilities being reduced or restricted. So, you kind of have to look at those little technicalities with regards to that. I don't know if it would be a rent increase if you're removing some of those services or facilities, because it sounds to me that you would be reducing the rent relative to whatever you're removing as far as services are concerned. So I don't believe the rent increase provisions would apply because you're reducing the rent in that case. But yeah, take a look at our amendment provisions and restricting and removing services or facilities. We have a lot more information on our website regarding those two topics as well. And, honestly, I might have missed some details here, but again, feel free to look at our website or even call our information officer line with regards to those kind of questions, because at least to me, it sounds like you're amending the tenancy agreement and restricting some services or facilities provided in the tenancy agreement.
Great answer. And I'll just provide a quick comment from my experience perspective. I've had a situation where landlords, originally had rent that included utilities and then wanted to divide them out, and actually was willing to adjust the rent down, but add this utility provision into it. And it was considered by an arbitrator, not that all cases are going to be equal, it was considered by the arbitrator to be a rent increase and did require 3 months notice to do it. So as Josh said, just be careful and make sure you take a look at the original agreement and what the tenant's agreeing to pay for. And it could be an amendment to the agreement, and it also could be considered a rent increase in some cases. So be careful. All right, that wraps it up for our session today. We are a little bit over time, but thank you all for attending. Thanks especially to our speakers and our 400-ish attendees. We'd also love to hear your feedback from today. When you log off, you'll get a pop-up link to our event survey. Please fill that out and send us your thoughts. Everybody enjoy the rest of your day and have a wonderful holiday season. Thanks so much for being here.
Thanks for having us, Darcy.
Thank you. Bye.